right, Mr. Howard, you tested negative, which is obviously good. Let's see. All right, and so Mr. Howard was previously in court, entered a plea of guilty to the third-degree felony offense of assault family violence.
Today's docket is a perfect snapshot of how the justice system balances second chances with serious consequences. We're going to see a man avoid a felony conviction after pleading guilty to assault family violence by impeding breath, a third-degree felony that carries up to 10 years in prison. Then we'll watch probation violations, bond increases for drug use while on felony charges, and a defendant facing revocation over injury to a child. And by the end, a DWI offender who technically receives a 10-year sentence, but walks out on probation instead. This courtroom isn't chaotic. It's calculated. Every decision carries weight. And the real question today is this: who earns leniency and who runs out of chances?
Assault family violence by impeding breath or circulation. I have received the pre-sentence report and reviewed it. Has everyone had an opportunity to review that pre-sentence report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
No, Your Honor. Not by the state judge.
All right, Mr. Hayward, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Obviously, that is going to include that you cannot have any contact at all with Brianna McClain. Are y'all still in any type of relationship? Okay. So if you're somewhere and she shows up after you, you're the one that has to leave. No contact, no communication, no sending messages, anything like that, okay? If you do everything you're supposed to, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never be a convicted felon. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could be sentenced anywhere in the range of punishment, which is up to 10 years in prison. Do you understand? Also, it's important that you understand, I know you've talked about some interest in going to the military and you've got some college under your belt and things like that. If you do everything you're supposed to and get that community service done, do any classes you're required to do early on in your probation, I sign early terminations from probation all the time. But it's going to be up to you whether or not that happens because you're going to have to do everything properly from the very beginning, okay? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. You also just need to have a seat here in the courtroom. Probation will call you to her desk when she's ready to go over your paperwork. All right, good luck to you, sir.
Thank you.
See, is there a Mr. Stringfellow?
Right here, Your Honor.
Good morning, sir. Are you ready to announce on John Roy?
We're not being put a plea paper.
Oh, okay, I'll hold that. Thank you, Mr. Parker. That I just sentenced? You want to send it to me or just? Oh, that's Alan's. Alan, can you get Miss Bridges back up here on one of the paperwork that came through last time? Her signature is either missing or didn't get on. If you'll come bring her, make sure y'all get that signed. Let's see. Mr. Rennick and Mr. Smith on Mary Lockard Fury. Good morning. Good morning. You're Mary Lockard Fury, and where are we?
I don't know, Judge. I was out last week on vacation, so I didn't get a chance to check with the U.S. Attorney's office. I think last time you were here, you who it was.
I talked to him. I did. I talked to Ray, and He told me they were trying.
I followed up as well, and I don't know what the delay is. I have been told by there are charges coming. The dilemma is I showed you the emails I had.
So
sent to them.
the information that I received was that they have not received documentation from all of the agencies that are potentially involved. And so from complaining witnesses from different areas, I guess, and different agencies, and so they were working on getting that. What he told me he would do, and hopefully he has, is reach out to the complaining witnesses in our cases so that they will know that this is not something that what's going on, that we're not delaying this just
I have
because
given him
that their
their
cases are being
names.
given attention, but being given attention in the federal system. So I'm hoping that he reached out to them.
I have explained to the victims in
Bless
these
you.
cases what's happening with these. I have told them what's coming, and I have given him their personal contact information
Okay.
quite a while back.
Yeah.
I know he's doing more than just Jefferson
I
County.
think he's got what he needs from us.
Let's break down what just happened, because this is significant. Mr. Howard pled guilty to assault family violence by impeding breath or circulation. That's not a minor charge. In Texas, that's a third-degree felony punishable by 2 to 10 years in prison. The judge found sufficient evidence to convict him. That means the case was strong enough for a felony conviction today. But instead of entering that conviction, she deferred the proceedings for 5 years. That's deferred adjudication, legally powerful and risky. If he completes probation successfully, the case gets dismissed and he avoids becoming a convicted felon. That could preserve future job opportunities, military eligibility, and civil rights. But if he violates probation even once, the judge can sentence him anywhere in that full 10-year range. And notice the strict no-contact order. If he sees a complainant, he has to leave. No messages, no communication, zero tolerance. So here's the question. Is 5 years of deferred probation appropriate for a family violence case? Or should incarceration have been
What he
immediate?
needs from us and our agencies, it's some other counties. And so I might shoot him an email again and follow up, because we reset this, bless you.
I mean, Judge, it was, to be honest, this would have, if the feds were involved, this would have been resolved.
Yeah, so I will, all right, let's do 45 days. And I'll shoot him another email just to kind of see where they are and get an update from him. Maybe if we all keep hitting them, they'll
I'll try
do
it again,
something.
too. Again, I would have, I was here last week.
That's all right.
I
Okay,
didn't have a
thank you.
copy.
Stay in touch with Mr. Rennick. He'll let you know when you need to be back.
Thank you, sir.
Thank you, sir. And then you've got John Sharp,
Yes,
Mr.
Judge.
Rennick.
Nicole, you and I, there's a video that I sent her last week. There's a civil case that's pending as well. And I think that you discussed an offer, but I think she wants the video from you before we finalize anything.
If you would allow, Judge, we had a good conversation last week. I just couldn't open the video, link he sent, so he's gonna try to provide it in a different fashion. I feel like that'll result in.
Okay, we'll just do a normal reset to give you some time to take care of that. Make sure you stay in touch with Mr. Rennick, Mr. Sharp. He'll let you know when you need to be back. Okay, you're free to go. Thank you.
The judge, the last one I have, Mr. Skinner, we're doing the paperwork right now.
Okay, I'll hold it for a plea. Thanks. See, Mr. Reynolds, you have Deshandra Joseph. To do what? For what?
You give me a minute. I'll go get her.
She's calling her name. Good morning, ma'am. You're Deshandra Joseph. And Ms. Joseph's case is set for trial to be in with jury selection next Monday. And what is the announcement?
Judge, I talked to the prosecutor. There may be a resolution to the matter. I think she One of a couple of
Judge,
days.
this is a case I picked up off another docket, Mr. Hoffman, last week. I was able to speak with the complainant. I was not able to speak with her daughter. If you would allow me the opportunity, maybe return that phone call today.
Sure.
And see, and I know you would like a pretrial announcement, but maybe a couple days.
No,
to
I
figure it
understand.
out.
I
Otherwise,
understand.
I could be ready very quickly.
So I guess what I'd like to do, if possible, is see what you guys can figure out by midday tomorrow, just so I have an idea to try to number the cases for next week. And if it is going to be something that gets worked out, I can always take care of that on Monday instead of this week if necessary. But just let me know where you
Yeah,
get.
there's a misdemeanor that is a companion to this case, and I think anger management may have been taken. So we just kind of need to figure out where we are exactly, but then if need be, the trial should only be 2 or 3 witnesses.
Okay, I'll just kind of hold it for you guys to get with me. Just call me or email or text in a group or whatever, okay? All right, stay in touch with Mr. Reynolds so that once he hears back from Ms. Malfino, make sure you're available to him to visit this afternoon, tomorrow, so that I'll know if your case is going to go to trial next week or not. Okay? All right, thank you.
Judge, here's the trial document.
Oh, wow. Look at that. I was just about to look for that. It's crazy how I always want these new things every week.
I know, I'm I'm concussed.
You are. You have every,
That's my excuse today.
use it. Use it while you can. Oh, this is next week, because you've got Master Word
Yes, ma'am.
for next week, okay.
For process.
Yeah. That's gonna be the, let's see. Mr. Doyle on Maverick Neal.
Autumn Payne.
Good morning.
Morning, Jeff.
Nice to see you back.
Thanks. Trying to get in better shape.
Good.
He's a little nervous, Judge.
Okay. We'll get through it. Good morning. You're Maverick Neal. And Mr. Doyle, will your client waive the formal reading of the indictment?
Yes, ma'am, he's going.
Mr. Neal, in cause number 24, DCCR 2436, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. That's from October 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
Nobody made you plead guilty, right? Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Did you go over these documents with Mr. Doyle?
Yes, I did.
Do you fully understand them? Do you understand those documents that you signed?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be giving up or waiving any right to appeal? So you can't change your mind later if I follow this agreement. Do you understand?
Yes.
And it looks like the agreement that you've reached is for, is that a 5
Yes, ma'am, I'm sorry.
5 years deferred probation? There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding of your punishment? So if I follow the agreement, you would be on probation for 5 years.
Yes.
Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Are you a U.S. citizen?
No.
Are you a U.S. citizen? Okay. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Neal is not competent?
Not that he's competent.
Okay.
In my opinion.
Thank you. And so, Mr. Neal, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. When you leave today, you need to stop and talk to probation on your way out, and she's sitting at that desk right over there. All right? So stop and talk to her, and then we'll see you back at sentencing. Do you understand? Okay, so you'll have one more court date for sentencing, okay? Okay, stop and talk to, right over there, the lady. Thank
Thanks,
you.
Judge.
Here's the date.
Thank you.
CP.
Mr. Gertz, you've got John Jackson.
He's right outside, Judge.
Morning.
Morning. How are you?
Good. How about you?
Good.
Good morning, sir. You're John Jackson.
Yes, Your Honor.
And Mr. Jackson's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Be ready?
State's ready, I believe, Judge. There's one witness that is unavailable, but I don't think it's absolutely an essential witness. I think our eyewitness and the one that we do need are available.
Okay. I'll number the case tomorrow after docket. If anything else comes up, just let me know. Is there any change in, looks like it was back in July, there was a rejection, any change in offers or anything like that?
Not that I'm aware of, Judge.
It was a 10-year deferred offer. Okay.
Understand.
Mr. Jackson, stay in touch with Mr. Gertz. He'll know tomorrow midday what the trial order is and when you need to be back next Monday. Okay. Yes, sir. You're free to go. And then you have Shay Morgan, Mr. Gertz.
It's not a problem. She's just on announcement.
Judge, she was outside earlier.
Jay Morgan, Mr. Roy Hay.
I'm sorry. Yes, and Judge, may I have like a few minutes? Can I hold on her,
Yes.
if you don't mind? I
Yes.
was all ready on the other people, but I'm not ready on her. And then don't surprise me with the next person you say.
I know. About David Hatcher. Is he here in the courtroom?
Yeah, he is, Judge.
David Hatcher?
And Judge, at your next break, may Ms. Malfino and I come and talk to you about something else?
Yeah, it'll probably be at the end of the docket.
That's fine.
Okay.
It doesn't matter. I'm patient.
Okay.
I got nowhere else to be.
Good morning. You are David Hatcher.
Yes, ma'am.
And Mr. Hatcher's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, we were close to a resolution the other day, but we're not. We don't have an agreement in this case. However, I have been in contact with my victim and their family. They're still going through occupational therapy and psychiatric evaluations all related to this, and he's not in condition to appear for court for trial yet, Your Honor. So I have to ask for a reset. I think we'll be able to get him down here after a reset. They live outside the Metroplex. But more importantly, his medical condition doesn't really allow him right now to come down to court and testify.
Any issue with a reset, one reset, Mr. Gertz?
No, not at all, Judge.
All right, so I will reset it one more time. Obviously, at that point, it'll be time to get it moving. So everybody be ready at that next one. But yeah, I'll give you some time on that.
We understand, Judge.
Stay in touch with Mr. Gertz. He'll let you know when you need to be back. All right, thank you. And then you're going to work on
This morning.
paperwork on Cracknell.
Oh, yeah, well, yeah, Mr. Hoffman's not here. And that was one of the things I'm concerned about. Like, Mr. Hoffbauer made me a whole new offer, as you know, but like, we haven't run it through.
That's okay. I think Miss Malfino. Oh, shoot, that doesn't work. That's going to be frustrating. Hold on a second. Hold on.
Jason,
Mr. Gilthorpe? Ms. Hawkins? Mr. Kimler, you've got Kashawn Purdy, 2 cases. Good morning, sorry, I missed you, and I called Mr. Kimler. Give me just a second, I'll recall your case, sorry. I looked up and looked right through you, apparently. You were in the corner. Yeah, definitely age before beauty on this one. Did you hear that? I don't think anybody would argue that one.
Purdy?
Kashawn Purdy?
This moment right here is where accountability becomes very direct. Mr. Joubert is 18 years old with 2 felonies pending, and he admits he smoked marijuana last week while out on bond. That's not just a poor decision. That's a direct violation of bond conditions. When you're released on bond, one of the standard conditions is obey all laws. Marijuana use violates state law and bond terms. The judge responds exactly how courts often do, by raising bond amounts to $15,000 in each case and imposing a drug patch condition. The drug patch is serious supervision. It continuously monitors drug levels, and the judge even explains she'll look at whether levels decrease over time. That's data-based oversight, not just positive or negative, but measurable trends. This is what escalation looks like. Instead of immediate jail without bond, she raises financial stakes and adds monitoring. Would you call this tough but fair, or should he have gone straight back into custody?
Good morning. Good, how are you? Yeah, glad to have you back. Good morning, you're Kashawn Purdy, and we've got 24 DCCR 1272. Ms. Purdy is on probation and has a motion to revoke that probation. And then 25 DCCR 1523, a new offense of injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, she was going to plead untrue to the new case, and I'm sure Mr. Nichols will have an opportunity to prove that in the context of the NTLP.
That's correct.
Okay, no agreements.
No.
And I do want to make sure, have y'all, it seems like 9 times out of 10, we set these for special hearing dates, we get witnesses here, and then something's worked out. So if you guys are going to work something out, then I want y'all to work it out, because I keep doing these and we set them for a hearing. I don't remember the last time I actually had a hearing on an MTRP. We get here, the state's brought witnesses, and
It was Mr. Hoffbauer's case, so I'm not sure. I believe, wasn't it Hoffbauer's?
It was.
Yeah. So, I'll solicit.
why don't I hold it for a minute? And let me hold it before we go through that motion. Y'all talk about it for just a minute. I just want to make sure. I mean, it's fine if you need a hearing, but I don't want to keep setting hearings just so that we see if witnesses really show up. And then we've got officers who have other things they could probably be doing that's more important. All right, have a seat, ma'am. Mr. Joubert?
Your Honor, she won't take the offer, so I'll just set it.
I'm sorry?
She refused.
Okay, that's fine. I'll do the plea in just a minute. How old are you, Mr. Jubert? 18 was the last time you smoked dope. What? Last week? What made you think that was a good idea with 2 felonies pending to come be smoking marijuana? You don't know? And you're not working? Obviously, you know that's a violation, number 1, of the law and of your bond conditions, right? Speak up. How do you think you're gonna get a job if you're smoking marijuana? What? You quit last week? Wow, congratulations. You realize how ridiculous that sounds to say I quit last week? Mr. Jubert, I'm going to find today that obviously that is a violation of your bond conditions in each of your cases. I'm going to raise the bond in each of your case because of that violation. Let me see what they were previously at. And cause number 25 DCCR 1130, I'm going to raise your bond to $15,000. And I'll go over conditions of both of the bonds in just a minute. And then in cause number 25 DCCR 1131, going to raise your bond in that case also to $15,000. Condition, if you make the bonds in both of those cases, is that you have to have a drug patch on at all times. You have 24 hours from the time you make a bond to get a drug patch put on. A drug patch is something that goes on your arm. Your bondsman can tell you where to get them. You have to have them changed every 2 weeks. If they test positive, then obviously I'll know you're still using marijuana and you haven't actually quit. You're going to go right back into jail with much higher bonds. I would anticipate if you make these bonds quickly that the first patch might be positive, but the patches are going to show me an amount, not just a positive or a negative. So if that amount is not going down, then I'm going to assume also that you're still using. Do you understand? All right, go back with the bailiff. Is that for me? Okay. Mr. Gray, come up, please, sir.
I do apologize for being late.
It's very important that you are on time because what happens is your bond gets forfeited. So I'm going to recall that bond forfeiture. Mr. Gray, did you have an opportunity to get someone hired?
Yeah, no, I can't support it, yeah, but I got your,
Who'd you talk to?
full list of them.
Just tell me who's on the list.
Corey Crimshaw, Solander Law Firm. Left a message with them, they called me back. It was $5,000, without trial, $10,000, total $2,000 down. Revoke Law Firm, W.M. Marcus, I think it's Wilkerson. I did the other one's Eric Franklin, $10,000 again, and $6,000 down.
Are you working, Mr. Gray?
Yes, ma'am,
Where do you work?
for myself.
What do you do?
State and federal labor law posters.
Say it again?
Labor law posters?
Okay. So what I need you to do, Mr. Gray, if working for yourself isn't going to make it where you can afford an attorney, then you need to try to get an additional job. Because it's important that you're able to try to hire your own attorney. You're able-bodied, there's no issues from what I can tell, so,
Sort of
what's that?
pancreatic cancer.
Are you on Social Security disability? Okay. Are you currently in treatment?
Well, we found out in November. think it's November. I think it's got me on meds for right now. And that's it, four of them. I gotta go back to Methodist and I owe that bill too, so.
What?
I owe that bill also for the hospital. Blue Cross and Blue Shield only pays for a certain amount.
Where are you going to the doctor in the hospital for that?
Methodist over in Conroe.
Okay. So what I'm gonna do, Mr. Gray, is reset your case for a normal reset. I want you to bring a couple of things. One, I want you to attempt to try to get a job if you can, or try to hire somebody still, talk to some others. But also, if you have, I want documentation of any current medical issue, appointments, diagnosis, things like that, and we'll see what your options are. Make sure you bring all of that. Step in front of the clerk. She'll give you your reset notice.
Thank you, I do apologize for being late.
Yes, sir. Yes, sir, thank you.
Thank you.
Mr. Garrett?
I apologize as well for being late.
It's very important, Mr. Garrett. Same thing. If you're not here on time, then you end up with a bond forfeiture and going back to jail. So make sure you try to be here on time.
Yes, ma'am.
And Mr. Garrett, were you able to get a lawyer hired?
Not yet. Courtroom lawyer, Brittany Holmes, is who was appointed to me, but
Did you talk to some lawyers like I asked you to?
I hadn't had a chance to look fine, so I gotta give you a regular job as well.
Right, but when you were here last time, I told you to talk to at least 3 lawyers and bring me those names, right? And you didn't do that. You just made that decision.
I'm gonna be honest. I spoke to people
Well, you're going to be honest about what?
that I hadn't reached out to anyway.
So, I mean, but it's so frustrating to me because I told you the same thing I tell everybody. What can happen if you don't do what I told you to do? I mean, it's not, I'm sorry. I mean, you don't want to go to jail, right? And so all you have to do is follow some simple instructions, talk to 3 lawyers, and you stay out of jail. Don't do that, and it's like you're just looking at me saying, I don't have to do what you do. Doesn't matter if you're the judge, and I'm sorry, and we get away with it. So I'm going to reset your case 2 weeks. You either need to get a lawyer hired or you need to talk to 3 lawyers within 2 weeks, which means you better get started this week. If you have not talked, that doesn't mean just calling and leaving messages. That means talking to about your case, getting their fees, and bringing me that information back if you have not hired someone. If you don't do that in 2 weeks, your bond will be raised for not following that court order. There's no I'm sorry at that point. You understand? Step in front of the clerk. She'll give you that reset.
Sign right here.
And I'll recall the bond forfeiture if I didn't already.
Okay, what is Skinner?
You're good to go.
Mr. Kimler, on Ms. Purdy,
That's, Purdy,
She's been friends.
I thought she wasn't taking a deal.
no, she's not. That's what I was saying.
Oh, okay, so you've already sworn her, but there's no paperwork.
Right.
Okay, all right, ma'am, again, you're Kashawn Purdy. And will your client waive the formal reading of the motion?
So,
Let me get this pulled up for me. All right, Ms. Purdy, in cause number 24, DCCR 1272, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 22nd of 2024 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of injury to a child, elderly, or disabled individual September 28th of 2025, and is that true or not true? Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
I'll give you some of.
true or not true?
When we come back for sentencing, you'll be able to explain. Okay, so true or not true? Okay. Count 3 alleges that you're behind in your court-assessed fees as of September 30th, 2025 in the amount of $1,832. And is that true or not true?
Not true.
Okay. So did you enter your plea of true to count 2 freely and voluntarily? That was the community service count. And did you plead true to that count because it's true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily. Time on proving up.
It's gonna require 2 or 3 witnesses, Your Honor.
All right, so here's what we're going to do. I'm going to set this for a hearing on the motion. Mr. Nichols will get witnesses with regard to any of the other counts, 1 and 3. I will not accept a plea agreement after today. So we're going to have the hearing. I'm going to listen to the evidence, whatever it is. I will make a determination on whether or not to revoke your probation, and then we'll see what happens on the new case once we have that figured out. But we're not going to negotiate. If y'all want to negotiate, if you change your mind and you want to enter some agreement, you need to get with Mr. Kimmler before that hearing date. Because once we get to that date, we're not going to just have witnesses here and then send them on because you changed your mind at that point. Okay? All right, and so we'll set it on a day when we have a little time for a hearing.
Thank you.
Stay in touch with Mr. Kimmler. I do need an updated report, please. And I guess any information, even though she didn't plea on the new case, any information that you can get would probably be helpful for everybody on that, even though we're not pleading on it on the pre-sentence report.
There's CPS.
So anything you think is important for me to know, get that information to Mr. Kimmler. He'll present it to me on your behalf when we come back. All right, you're free to go.
Thank you, Your Honor.
Thank you, Mr. Nichols.
Just stay in touch with Mr.
Ms. Hawkins, on Devin Spites, that's sentencing. Good morning, you're Devin Spites. And Mr. Spites was previously in court, entered a plea of guilty to the 3rd-degree felony offense of theft of property. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, ma'am.
Are there any additions or corrections?
Not to the information. I would like to be heard on the recommendations of the judge.
Well, let's start on the fact that he denied it. So he denied the offense. So I'm not sure about accepting the plea agreement. So I don't know if you want to visit with him about that statement and what he meant or didn't mean by that. But we'll talk about the recommendations once he pled guilty, so he can't not take responsibility now. Do you want me to hold it for a minute while y'all go over that and visit about it?
I can speak with him about that.
Okay, I'll hold it.
Judge, I had on my file, even though it doesn't reflect on the PSI, that he pled true to paragraph 2, which I think is
It would make it a what?
second.
Oh, okay. I'll look back and make sure of that as well, so that can you look, pull up the plea papers on,
That one I can send them to you.
Devin Spites? And I can look at the indictment and tell from here.
It should be on your tablet, Judge.
Thank you, ma'am. Yep, you're correct, Ms. Malfino. It's on the indictment. I wrote it down.
Ms. Hawkins, he votes.
See, Mr. Gilthorpe, did I see Mr. Gilthorpe? On sentencing on Gregory Vasquez. Good morning. Morning. Good morning, sir. You're Gregory Vasquez. And Mr. Vasquez was previously in court, entered a plea of guilty to the third-degree felony offense of driving while intoxicated. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, Your Honor.
Any additions or corrections?
I didn't see any, Your Honor.
All right, Mr. Vasquez, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That includes all the standard rules, but it also includes entering and successfully completing the JCDI program, as well as having an auto ignition interlock device on any vehicle that you drive, which you should probably already have based on your bond conditions. You are ordered to serve 10 days in jail as a condition as well. And what's your position?
We'd ask to do those on weekends, and if not, weekends are not available, we'd like to schedule that out so he can let his job know.
Where you work during the week every week?
Yes, ma'am.
Where do you work? Okay, so any issue with weekends?
No, Your Honor, there's no problem with that.
So I will allow you to serve your 10 days on weekends, and that will start this Friday. You will be ordered Friday the 6th. Friday, today's Monday. Are you already putting us at Thursday?
Yes.
You're ready for the week to be over already. We just started.
This Friday.
This Friday, February 6th at 6:00 p.m. You will report to the Jefferson County Jail, spend the weekend there, and then you'll do that every weekend until you serve those 10 days. It's important that you're on time at 6:00, that you don't skip, you're not late. It's also very important that you don't show up under the influence. Some people think it's a great idea, show up under the influence, sleep it off over the weekend. It's a violation of your probation. You'll be right back in here. And so if you do everything that you're supposed to on this probation and complete it successfully, this is a great opportunity because for all practical purposes, your case here in court is over. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to
Today's
appeal.
docket showed every layer of judicial discretion. Mr. Howard avoided a felony conviction through deferred adjudication, but only under strict conditions, and a looming threat of up to 10 years in prison if he violates probation. Mr. Joubert had his bonds raised and was ordered to wear a drug patch after admitting marijuana use while facing 2 felony charges. A clear warning that bond freedom comes with responsibility. Miss Party now faces a motion to revoke probation and a hearing that will determine whether she loses her deferred status entirely. And Mr. Vasquez, after pleading guilty to felony DWI, received a 10-year institutional sentence, suspended, and 5 years probation with ignition interlock, JCDI completion, and 10 days in jail served on weekends. That's accountability paired with structured rehabilitation. What we witnessed wasn't random. It was calibrated justice. Opportunity where possible, consequences where necessary. Now I want to hear from you. Which ruling stood out the most? Did the judge strike the right balance across these cases?
Your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gilthorpe. All right, sir, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you.